Hello, everybody. Welcome back to the Law and Crime Network. I'm Michael Bryant. Joining me on set here, Emily Galvin Almanza, and I can't wait to get into tons of stuff with her, and two other guests hanging out in the ether. Dr. McElfresh with another look at some of the DNA, as he has testified to a couple of times. Right now, remember, he's on in the rebuttal case, being cross-examined now by the defense in this case. So we're going to take a quick opportunity to chat with everybody. I mentioned I have Emily Galvin Almanza here in the studio. She is not just the senior legal counsel for the Justice Collaborative, but also the CEO for Partners for Justice and an author, which we can get into a little later. Clearly, you can't keep a job. So thank you for being here. I appreciate it. Joining us as well, Joseph Scott Morgan, our forensic death investigator. And speaking of books, check this book out, Blood Beneath My Feet. I think, Joseph, is that in the children's section, that book there? No? Okay.
Lord, I hope not, because then they're going to have to go for therapy after that.
Okay.
There you go.
Also with us, Nicole DeBoard, former prosecutor, criminal defense attorney, and I have it on good authority as a Texas super lawyer. Am I getting that right?
This is true.
Okay, guilty as charged. Okay, let me start with you, Emily. A lot of DNA, and we've talked about this over the last couple of days, that at some point there's some saturation, some oversaturation, some overkill. The jury might just be glazing over. What should we get out of all of this DNA discussion?
I think the biggest takeaway is that so many people assume that DNA is a clear yes or no in a case, guilty or not guilty. DNA will tell you if someone was there. And I think what we're seeing here is an amazing education in how subject to interpretation DNA really can be. As the technology gets better, as I'm sure my colleagues on the screen will talk about, the sample size is getting smaller and smaller, the mixtures we're able to examine getting more and more complex. The level of certainty is certainly diminished, and the level of interpretation is increased. And what we're seeing here is endless interpretation that might be a little bit hard for the jury to stay excited about.
Yeah, and I think, Joseph, the key argument here from the defense, and they are handling the cross at this moment, is that Mr. Quinones, who we saw earlier in a long deposition while he was in Italy, why would his DNA be there in any form, in any manner, unless he was in fact involved in the hit, as Mr. Santos has testified? Why would it be there?
Yeah, you would have an expectation that maybe to a certain degree that the defendant would have DNA that was deposited there and that was specifically identifiable. But for Santos, what's where are you going to go with that? How are you going? Because he's got a specific DNA profile, and did he have some level of intimacy? And I don't mean in a sexual nature. I just mean in a in kind of this familial group that we had in this home. There is no reasonable explanation that we can draw or that we can conclude. And if I can go to the larger point here, what you were addressing just a second ago, I like to refer to this, and I've said this before on the air even this week. This is what I refer to as death by science. The defense is more than happy to allow this to continue on because, these jury members are human, Michael. They can only take so much. They didn't sign up for this necessarily, all right? They're compelled by law to listen. But, you still have to get past this in the brain, and it's a brain drain unless you're engaged in science and you want to understand this. It's very difficult to digest all of this data that's being thrown at them right now.
Yeah, I think if we had a look at their notepads, we might see some doodling on there in the midst of a lot of this testimony. Nicole, is it hard sometimes as the attorney putting on the case to kind of distance yourself and say, maybe this is enough. Maybe we have what we need. Let's move on.
I think it can be, but interestingly, from my perspective, I think as a defense lawyer, when you have something that the prosecution wants to say is so very certain, you want to do everything you can to help the jury understand that there's such a small quantity of evidence with such a broad amount of interpretation that tells us what it's supposed to mean, that any small amount of human error in the interpretation can make all of this evidence just totally useless to the case. Yeah. So it may be wise for the defense to just beat and beat and beat this drum.
Oh, well, we're going to find out. The jury could have this case as early as Tuesday. Again, we're talking about the case in Florida against Henry Segura. This is a quadruple murder case. It is a death penalty case. And welcome back. We're in Tallahassee for the case against Henry Segura. The court is on a break. We've just finished that videotape presentation from the cellmate of the defendant, Mr. Kennard, who says that, hey, Henry Segura told me all about it, even wrote a rap song about it. That is done. I'm guessing they're trying to figure out if there's more to go today or not as we mentioned before, now I'm hearing they're done for the day. A voice in my head tells me they're done for the day. So now we know what's going to happen is they've done things a bit out of order, a little cattywampus here. The rebuttal took place today because the defense has at least one more witness that they could not call today because of availability. That witness will be called on Monday, and closings could be as early as Monday afternoon, perhaps Tuesday morning. So that gives us a chance to catch up on what we've seen in this case and kick it around because the jury is going to be kicking it around very soon. Emily Galvin Almanza is with me here in the studio. So we've talked about not a lot, but a little bit about this the snitch concept and how helpful it may seem, and yet it could backfire in this particular case because it looks sort of desperate. So if you're on the jury and you're overwhelmed with the DNA, as they apparently have been, it's a nice break, if nothing else. But do you have a sense of how juries view snitches in general?
I think it's a pretty disfavorable viewing, especially in a case like this where the jury's naturally going to compare the Santos testimony to the Kennard testimony. You've got two fellows testifying from in custody, one who's accepting responsibility in a very dangerous way. I think in the first case he pled the fifth. Who's accepting responsibility for ordering a hit, and the other guy who's making up his fourth story in a long history of making up stories, who's now no longer available, whose whereabouts have not been addressed.
And it's funny, we don't know that the jury will ever learn why he's not available. Is he out and he's skipped the country, or is the federal system not cooperating with making him available? We don't know, and the jury is unlikely to know. Joseph, earlier today we heard from another remote witness, and it was from a deposition done of Mr. Quinones from back, I think it was some point just before the first trial. Anyway, his testimony was effectively, hey, I don't know anything about it. Remember, his DNA was found at the crime scene, and Mr. Santos has fingered him as the guy Santos sent to do the hit. So how do you wriggle out from under that if, I don't care how many times from Italy he says, nope, don't know any of the people involved, I don't know a thing about it. It can't square with the jury when they've seen some of this other evidence, which is your kind of evidence, the scientific evidence.
Yeah, Mike, this thing about it is, say what you will about DNA, but as everybody knows, it's very, very unique to each and every one of us. And it's very hard, as you say, to square this. How do you explain this very specific biological evidence with very specific biological markers that wound up at this location? And you've got another person that's testifying to the fact that he's the trigger man. He's the guy that was sent on this mission to just wipe this woman out and unfortunately wipe these children out as well.
Nicole, we heard from that witness remotely and under bizarre scenario. I mean, when you have a witness being deposed, you would like to have them in some sort of environment in which you have some control. In this case, I guess there was counsel there in Italy at the embassy, but there was no pressure per se for this guy to tell the truth. How important is that for the process in trying to get the most credible information?
I think that the jury can see through this kind of thing. I think when you have a witness that doesn't have the right kind of interrogation from the opposing party, doesn't have an aggressive one, and they're just sort of let to run with whatever information they want to, make up along the way or share, the jury starts to make up their own questions. It's certainly better, I think, if you have a live witness and you can address things as they come up in the courtroom. But where you don't, I have to agree that this looks like a desperate move by the prosecution to put this guy on.
And, we've heard that term quite often, folks using that phrase, desperate, and they wonder maybe, well, why are we doing a retrial when this thing seems to have so many holes prosecutorially? So, Emily, what are some of the factors that might go into the prosecution's decision on whether to retry a case, especially in the face of an 8-4 verdict or 8-4 tie that was in the favor of acquittal?
This is one of the things that baffles me the most, because a decision like this has to come down from the leadership in a DA's office, a case that's high profile, that's very serious. This is clearly a considered decision, and it's an institutional decision. What I don't understand is that it appears to me to be a decision that prioritizes winning over the prosecutor's true purpose of finding truth and seeking justice. Prosecutors have a unique ethical obligation that is different from every other type of lawyer out there, which is to do justice. Other lawyers are bound to do the best representation for their clients, but prosecutors are supposed to protect the community. Here you have prosecutors choosing to chase a narrative that just doesn't add up, contravening the reaction of the first jury, and abandoning, in many ways, their obligation to seek the truth.
You know, you're a former prosecutor, Nicole. What goes through your mind? Is the family, the victim of the family members, one of the primary elements of the decision-making process? You want to do the best you can for them, so let's give it another try. You're the prosecutor. What are you looking for to retry a case that's like this one?
You know, that's a difficult thing for me to answer. I have to say, I mean, you have limited resources as a prosecution, and you have to decide whether or not it's worth going back to this case that you've already put so much time and effort in. You've already heard from a jury once. Why are we doing this again? It's to me, as a prosecutor, I don't think it's an effective use of resources or time. There are probably many other cases out there waiting for their day in court, and yet this is the one they choose to use. So, you have a limited amount of time in court. You have 52 weeks in a year and a whole lot more defendants in most courts that need to have their cases heard. So I have to say, this is a questionable decision.
Hey, Joseph, I know, and we have a short time here before the break, so in about 30 seconds, this is not the best DNA case we've ever seen. Are you, as a professional, surprised at what they found and what they didn't find?
Well, yeah, I'm surprised. They're wanting to attach this guy to the case so desperately, and that attachment is lacking, I think. And so that in and of itself is profound. It's a profound demonstratively. And I think that the defense needs to continue to hammer at this. I think they've done a pretty good job thus far. And they're going to wrap things up, we hear, on Monday. So stay right where you are. Going to take a quick break. Coming back after the top of the hour with more from Florida following the Henry Segura case. Stay where you are.